Hello and welcome to this video lecture on plaint documents and their components, which is part of Unit 2 of our program on civil drafting for practicing advocates. Hi, I'm Richa Kaur. In this video lecture, we'll go through the various components of the statement that the party filing the case submits to the court.
Hi, I'm Aditya Narayan. In the previous unit, we explained the concepts of drafting, civil and proceedings, delineated the trial process, outlined the difference between trial and appellate proceedings, and explained the adversarial system of adjudication. In civil proceedings, the party who commences the case before the trial court is called the plaintiff, and the document that he files into court is called the plaint. The plaintiff, and the document is called the plaint. These terms differ when applied to different proceedings. For instance, in a civil court, the term plaint is used to describe the document filed by the plaintiff in a suit. But in an arbitration before an arbitral tribunal, the same document is called a claim statement and the party is called a claimant. In proceedings under Section 9 of the Arbitration and Conciliation Act 1996 for interim relief from the court, an applicant files an application. And in others, such as consumer proceedings before consumer fora under the Consumer Protection Act 1986, the party filing the case is called the complainant and the document filed is called a complaint. Irrespective of nomenclature, these are all written submissions that are filed to initiate litigation at the trial stage and share common characteristics of form and content. For convenience, we will collectively describe these written submissions as the plaint document. You will find detailed notes on the individual components of the plaint document in the reading materials related to this unit, and we will go over them later in this video lecture as well. But before that, it is important to understand the role that the plaint document plays in the trial process. As you learnt in Unit 1, the trial comprises of 4 important stages: pleadings, issues, evidence, and arguments. The plaint document plays a major role in 3 of these 4 stages. It forms a part of the pleadings, and it is important to ensure that every relevant fact is stated in the plaint document. Based on facts pleaded in the plaint document, the court frames the issues in the case. And then the parties can lead evidence. Facts that are not pleaded may not be proved in evidence. The points of law do not require to be pleaded. Therefore, the arguments that the plaintiff makes may not be affected by the plaint document. It is important to note these points while drafting a plaint and ensure that the material information is incorporated into it at the correct places. As the reading material spells out, the components of the plaint document are the cause title, the body, the prayer column, a verification, an affidavit in support of the document, evidentiary material that you produce in support of your case, and the wakalat. The cause title sets out important details including the court before whom the case is filed, the year of filing, the type of case, the case number, the parties' names, and their addresses. The cause title is an important component of the plaint document. The parties' names and addresses as set out in the cause title are used by the court to issue notices, summons, and for other court processes. The next component of the plaint document is the heading, which should ordinarily state the legal provision under which the case is being filed. The heading forms a part of the body of the plaint document. The aspects relevant to drafting a plaint document are set out at length in the reading materials. As we noted earlier, be sure that you state all material facts while drafting the plaint document, but exclude all legal submissions. Material facts are stated in the plaint document, while legal submissions are excluded. From a drafting perspective, remember that the body of the plaint document must always state that the court has jurisdiction that the proceedings have been commenced within limitation period and that the requisite court fee has been paid. Finally, the concluding portion of the plaint document is always the prayer column. It is at the foot of the document and is a formalistic statement seeking relief from the court. Remember that care should be taken to ensure that the prayer is phrased correctly, so that your suit is not dismissed on a technical ground. The plaint document contains two affirmations by the plaintiff that its contents are true and correct. These are the verification and the affidavit. The affidavit ensures that if the plaintiff makes false statements, he would be amenable to prosecution for perjury. The plaint is accompanied by a list of documents that the plaintiff relies upon. The Code of Civil Procedure requires that the plaintiff produce all documents in his possession at the time of filing the plaint document, or state that he does not have the document at that time in his possession, if that be the case. Failure to do so renders him ineligible from producing the document at a later stage. All documents that you produce should be attested. If you produce documents in original, you may request the court to retain them in safe custody. Courts will direct such retention if requested. The plaint document is accompanied by a wakalat, which is a letter of authority granted by a client to represent him in the case. Ensure that it is duly executed, and where you have not seen the client execute the wakalat, it is a good idea to have it notarized. The wakalat is always placed at the end of the plaint document. This brings this video to a close. To summarize briefly, in this video, you have seen what a plaint document is and its various forms, depending upon the nature of the proceedings involved, the relevance of the plaint document to the adjudicatory process, and its several parts. Thank you for watching. You should attempt the practice exercises before moving on to the next unit.